Good evening. Captain Retired Matt Edwards here with the next installment of the Facebook Live Observation Post Weekly Report for the 16th of May, 2024. If I forgot to mention that, I got slightly off kilter there at that time and I wasn't sure if I had it right. Feeling a little bit tired. I almost skipped this broadcast, but I had an idea that disturbed me so much. I'm fighting off to being tired enough to talk about that topic, plus I'm going to go through what I've been doing lately is trying to limit myself to one or two what I call observation posts. Now, just in case you missed it, the name of my group is a joke, sort of. I post what I observe. Now, in the military, an observation post is set up to observe the enemy too, so there's that as well. So what I'll do is I'll go through my observation post number 1 today. Don't think I did the second one. And I'll explain some of the stuff in detail. And then I'm going to talk about inflation protection as per the Canada Gazette in 2016 and how disabled and service veterans are getting screwed over. Okay, so the first point I mentioned this morning when I put this on, and this is a topic that really disturbed me. Veterans Affairs Canada / Service Income Support Insurance Plan as welfare. Now, editorial note, I'm very well aware because I have a negative connotation, a negative feeling toward the word welfare, but I'm doing it for the shock value instead of counting it, social assistance, income support. I'll call it what, gets people riled up, welfare. Now, I know this term is offensive, but it is intentional on my part, as disabled veterans should not be paid welfare. A. The Service Income Support Insurance Plan, SISIP. The name actually includes income support or welfare. So that's my first piece of evidence to prove my point. B. SISIP claws back income, like welfare uses a means test or an income test to reduce costs for the taxpayers. C. Veterans Affairs Canada also uses income testing to see if disabled and service veterans are eligible based on financial need. Now, I'll elaborate on that one point because I'm not very impressed with the government moving from what used to be a rights-based pension to a needs-based system where they don't pay you if you can afford to pay for your own financial needs. Now, a lot of people will say, why should we pay? You should pay for yourself if you can. Well, if you were getting welfare, I'd agree. But because you're supposed to be getting compensation for your injury, go fuck yourself. Now, I better watch it. I'll get too vulgar when I get triggered about this shit. Now, D. Veterans Affairs Canada's literature includes welfare terms many times. Now, I never went and looked it up, but I meant to. I might have it in the pictures because what I do, I am very well versed in what people think these days. They think that you just have an opinion. But everything I say is fact. Everything that I say is backed up by facts. It's not an opinion if it's a fact. Okay, point number 2, Canada Pension Plan Disability, direct payments as corporate welfare, or a subsidy for insurers, which includes employers who self-insure. A. Canada Pension Plan is a self-funded contributory pension with a disability insurance to Canada Pension Plan Disability, so no one subsidizes this program. The government doesn't subsidize, the employer doesn't subsidize, the worker pays 100% of the premiums, the contributions. How do I know that? Because I read it in a case. Granovsky, Supreme Court of Canada, year 2000. Now, I'll probably go back there later when I look at the pictures and I'll read off a couple of quotes if I feel like it, because again, I'm not getting paid to do this. I'm doing this trying to educate the public about how the government is gaslighting, stealing from disabled veterans. Now, B. The Crown makes it appear as if the employer subsidized the worker by splitting the contribution into 2 halves, but the half paid by the employer is paid on behalf of the employee. Again, I quoted Granovsky, I put that in brackets as my legal citation to prove my point. C, many employers self-insure. Now that's a statement. It's not part of the proof, but it's part of the logic getting towards making the proof stick. D, in 1991, the Crown wrote Section 65, brackets 3 of the Canada Pension Plan to allow a retroactive payment to go directly to an insurer, subsidizing directly with a Crown debt owed to the contributor. E, this is the proof of why that shouldn't happen. 4 years later, in 1995, in the Beatty, Ontario Superior Court case, the Department of Justice stated that there are laws put in place to protect Crown debts, such as the Canada Pension Plan, which would include Canada Pension Plan Disability. So I guess they forgot that they wrote that law to give the insurance companies a subsidy. F, in the common law, a pension is meant for the exclusive benefit of the contributor. So Section 65.3 is illegal in the common law, okay? Because pension law is based on trust law. It's not based on legal technicalities. It's based on equity, fairness. G, directing money to anybody other than the contributor is also bad public policy, as it increases pressure on the Canada Pension Plan when others try to upload or offload the costs, meaning that there is more payments out of the Canada Pension Plan if people get approved, and more administrative expenses, even if people fail in their application. You can't tell me it's good for the cost of the system more money. So the insurance companies and the employers who want a break make people apply for Canada Pension Plan Disability, oftentimes when they can't legally get it because of the 4 out of 6 year rule. So then the Canada Pension Plan, the medical system, they have to incur extra costs. Now, it even costs the Canada Pension Plan more money because they pay the doctor instead of the province is paying the doctor. There's a special fee that goes to the doctor to pay them for the medical exam for the Canada Pension Plan Disability application. But again, there's no money coming off the insurance company that wants to get the person off of their insurance and onto the Canada Pension Plan Disability instead. They don't pay it. H, conflict of interest is very present to any reasonable person, including myself, as the Crown self-insures with SISIP, Great West Life for the RCMP, Public Service Management Insurance Plan, and Sun Life for unionized employees. The Crown is one of the largest, if not the largest, employer in Canada, so the long-term disability expenses are getting transferred to the Canada Pension Plan, which is not funded by the government. See? So point number 3. Now, moving on with that, I think I'll be finished early tonight the way I'm going. Point number 3. How we get fooled, at least in part. I was watching some show, I think on YouTube, or it might have been on TV, and it was talking about how Trump's facilitators, like Fox News and all them right-wing broadcasters, they fool people by this opinion guy, like Tucker Carlson gets on and states something, you know, some kind of bullshit, and then the next day, the news department, instead of the opinion department, picks up the opinion and then broadcasts it as if it's news. Now, I'll use the example from the pain and suffering bullshit. Somebody put out the idea, a false flag, a rumor, that the Pension Act was for pain and suffering. It's so far from the truth, it's unreal. But then it started to gain momentum as people, you know, the government put out rumors, so people believed the government, and then other people picked it up, and then people wanted to believe it. So because they wanted to believe it, and part of the reason they wanted to believe it is it gave them an answer to a solution to the problem of the Pension Act being clawed back from SISIP. So government was saying it's income, so we had to claw it back. So somebody spoke up and said, no, it's not, it's pain and suffering payments. It's not income. Well, I got news for them. Whether it's economic or non-economic damages, neither of those is income. So they didn't have to say it was for pain and suffering. All they had to do was say, listen guys, the Pension Act is the exact same thing, the equivalent for civilian workers having workers' compensation. And because they replaced the lawsuit in tort with the Pension Act pension, a lawsuit in tort is a payment of capital to replace a capital loss. So therefore, damages are not income because they are capital. And if you replace the lawsuit in tort with a pension, then it has to maintain the capital nature. So when a person gets a monthly payment, they're getting a monthly capital payment, not a monthly income payment. Now, that should have ended the discussion right there and then. Could they take it into account? Because nowhere on Section 24A of the SISIP policy did it say that they could take into account tort damages. Now, they did put it in Section 44A, but the judge crapped all over them about putting in there things that were not contractually justified. So, okay. No, you know what? I missed something, I think, up there. Oh, no, I'm looking further down the page. Okay, so, A, somebody voices the idiotic opinion that the Pension Act pension is for pain and suffering. B, someone else reports that bullshit as if it's true. C, over time, the bullshit becomes real to the people that want to believe the bullshit. D, fact, property is never pain and suffering. Right? That's common sense. Fact, pain and suffering can sometimes, not always, be a head of damages in a tort lawsuit. Sarbanes, Supreme Court of Canada, 2002, is my reference. But suing for pain and suffering as a separate head of damages when a person gets a pension is not an option, according to the judges in the Supreme Court of Canada in the Sarbanes 2002 case, unless they are wrong. Now, this is where I'm not a lawyer, but I've read so much law, I think I can make a fairly good legal opinion. So I said, gee, my opinion. The Sarbanes Supreme Court of Canada 2002 case was wrong, generally. Oh, well, yeah, about the ability of the pensioner to get pain and suffering. Why? The Crown limited the exceptional incapacity allowance to 98, 99, and 100% pensions awarded on the table of disabilities. Now, because they limited it to such a small group, the vast majority of veterans getting a Pension Act pension do not get a pain and suffering award. So that means they're only getting economic awards. That means that the government should have to pay them some form of pain and suffering, in my expert opinion, even if it costs them more money. Now, then I put, because I said it, the reasoning behind my logic. Then I put the Sarbanes Supreme Court of Canada 2002 excerpt, paragraph 29. This breadth is necessary to ensure that there is no Crown liability under the ancillary heads of damages for the event already compensated. Sounds okay, right? So I put down footnote 1. The compensation principle supports this point. I didn't disagree with him, did I? Because it's right. Then the next sentence, because I divided it up into sentences to make it easier to analyze and footnote. Easier to understand, too. That is, the Supreme Court continues, a suit only claiming for pain and suffering, or for loss of enjoyment of life, could not be entertained in light of a pension falling within the purview of Section 9 of the Crown Liabilities and Proceedings Act, merely because the claimed head of damages did not match the apparent head of damages compensated for in the pension. Now, as I'm reading that, I'm thinking it's more bullshit than I said when I footnoted it. I said point number 2, a tort lawsuit for pain and suffering for a pensioner would be barred under CLPA Section 9 according to the Supreme Court of Canada ruling that I think is flawed. Flawed because they failed to do their job as judges. Then I quoted why I think the judges were incompetent. Statutory Instruments Act Section 16 states that judges will take notice of federal statutory law. Pension Act Section 72, which is the law they should have taken notice of, and the Hansard in 1970. That was when they brought in the Pain and Suffering Award called the Exceptional Incapacity Allowance, and they limited it to 98% or higher. So judges shouldn't just spout off shit. They should do their research. They should look up the Hansard. They should look up the acts, not just the Pension Act, not just whatever other act. Sarvina's case was about the Canada Pension Plan. So they, like all laws in a common law democracy like Canada, are supposed to form one cohesive whole. So the judges ought to be very familiar with a couple of laws. The Statutory Instruments Act, because judges are supposed to take judicial notice of laws, and the Interpretation Act, which says that laws had to be interpreted broadly and generously so that they achieve their object. So basically I'm saying they fucked up bad. They didn't think so, or they wouldn't have ruled that way unless they're corrupt. Now, the thing I don't like about this that is occurring to me, remember I said that I thought of something else? I'll read it out again. That is, a suit claiming only for pain and suffering or loss of enjoyment could not be entertained because the head of damages did not match the apparent head of damages compensated for in the pension. Well, they didn't say what the head of damages that the pension compensates for, did they? For 99% of the people getting the pension, it's economic damages only. No pain and suffering. That's because most people don't get the exceptional incapacity allowance. Now, anyway, I'll be here all night if I got to try to remember what I thought of earlier, because that thought is gone. So carrying on with the third sentence, all damages arising out of the incident which entitles a person to a pension will be subsumed, which means brought into, under Section 9 as long as the pension or compensation is given in respect of or on the same basis as the identical death, injury, damage, or loss. Again, on the surface, this sounds reasonable. But let me give you, in my footnote 3, again, I agree with the point, except for A, the Pension Act Section 25 allows 50% of a tort lawsuit damages to be kept if the person sued was not the Crown, implying that a tort lawsuit is allowable, even when a person's getting a pension. Or Crown Liability and Proceedings Act Section 9 does not apply, right? How can they have a law saying they're going to take half of the money into account if you're not allowed to sue because of Crown Liability and Proceedings Act Section 9? It's illogical. B. Section 25 also states that 100% of the damages will be deducted when the Crown is sued successfully. Crown Liability and Proceedings Act Section 9 bars lawsuits against the Crown, so that law is vague constitutionally and not enforceable. But I'll tell you another reason that law is not enforceable, because they can go fuck themselves, because the rule of law principle says if it's 50% for a civilian, you can't jack it up to 100% deduction when it's the government. You just can't give the government an advantage like that. You're not allowed to. It's supposed to be one rule for everybody. So it's either 50% or 100% for both, or possibly 0%. Now, C. This is a case I talk about a lot. Salts, British Columbia Court of Appeal, 2006, shows the problem with Crown Liabilities and Proceedings Act, Section 9, and Pension Act, Section 25, in that the common law provincial court ruled that Pension Act, Section 30 did not apply. Well, the judge didn't mention it, ignoring federal law. Remember that Statutory Instruments Act that I told you about? But the main problem, as I see it, is the conflict created between the debtors who owe money to the victim that they created, and the debtor must pay damages to make the victim whole. This is not a hypothetical issue. Saltz was a real case where the Pension Act was taken into account and clawed back from the damages that the former RCMP member suffered. So they set up a conflict between the provincial court judges and the federal Veterans Affairs Canada. Because which one takes priority? Okay? Should the damages be taken into account to reduce the federal government's liability under the Pension Act, or should the provincial court take the Federal Pension Act payments, which are in lieu of damages, convert them into a lump sum by taking the monthly amount and then converting it to a lump sum and then deducting it from the damages? Now, in either way, the veteran is getting fucked over. But should they? It's not their fault that, two different people had to pay damages. Because I don't see a way around this that could satisfy. Because why should, in a federal system, we have a federation of provinces making up the federal government? Now, the province of BC hired the RCMP to police the province of BC. The RCMP officers that were working there in the same office as Nancy Wilson Saltz harassed the shit out of her and caused her to become injured. She then got a Pension Act pension. She got her Great West Life long-term disability insurance because she was an RCMP member. She got her Canada Pension Plan disability. And she got her RCMP Superannuation Act pension. And then she got the damages. Now, when it went to court, they said that the Great West Life payment can't come off because that's insurance. The Canada Pension Plan disability can't come off because that's insurance-like. And then they only wondered, should they take the RCMP Superannuation Act pension into account, which is stupid because it shouldn't have even went to trial, because that is another contributory and non-indemnity pension. But the judge did rule it right, but it was a waste of a case, because why should it have gone to court? All pensions are non-indemnity and contributory. Non-indemnity means they don't indemnify, they don't pay someone back for their injury, their loss. That's why Veterans Affairs Canada can't take into account the Canadian Forces pension or the Canada Pension Plan, because they don't indemnify. See? So it's almost like the SISIP case all over again. Now, the only thing that was allowed to be taken into account was the Veterans Affairs Canada pension. And that should have people scratching their heads. They should be saying, if they believe the bullshit about pain and suffering, how come that judge allowed the Pension Act, which is a pain and suffering award, that's not income, how come they allowed that to be taken into account? Now recall, this is before the Manouche case. This was 1 year prior to when Dennis Manouche started his cases. So on the very first day, when Dennis Manouche filed his lawsuit, the judge should have said, listen, government's wrong. Dennis Manouche is right. Last year there was a case, Nancy Wilson Saltz versus BC, or whoever, and you win. But instead of that, they dragged it out for 5 years, and then they came up with some bullshit about, the Pension Act is not income. It's pain and suffering. Well, it's pain and suffering damages if you get an exceptional incapacity allowance. Anyway, let me go on now because I got my pictures. Now, I'll go through my pictures that I posted and explain why I posted them. Okay, so the first picture I put there, and these days I'm doing a much better job, I think, of referencing my pictures, so that I'm not saying I wonder where I got it. Because right up in the top left it says 2013 Earnings Loss Audit. So this is an internal audit of Veterans Affairs Canada and the Earnings Loss Benefit System. And they said up on top, and I put a big red box around it, Income Support Committee has been established. Income support is welfare. So go fuck yourself. You want to say income security. You want to say compensation security or some fucking other word, but do not use a welfare term, okay? Do not fucking use income support, ever, when you're talking about having a replacement for a lawsuit in tort. If you get injured and someone else has to pay you, it's not welfare. They're paying you back for the legal damages, the equitable damages, the harm that they caused. Okay? I might as well read it all off and see if they can jump out of me. A working group, the Income Support Committee, has been established, and the Terms of Reference, TOR, has been created, which states that the role of each member and area. The mandate of this committee is to ensure that appropriate coordination, integration, and communication with respect to the income support programs, which includes the earnings loss benefit. The committee provides a forum for discussion and resolution of issues and contributes to the program's improvement. Blah, blah, fucking blah. Sounds like they're saying a lot of words without saying anything concrete. The committee either escalates the issues to the Interbranch Directors Committee or refers them to the legal services when required. Now, I don't know what the fuck that whole context is about, but it sounds like there's some interdepartmental, interagency rivalry going on with these people. Now, the second picture, when I scroll forward, is about the Granovsky Supreme Court of Canada case in 2000. Paragraph 2. The appellant raises issue of considerable importance to people with disabilities and the governments that undertake to design and implement social benefits legislation. Again, go fuck yourself. This is not social benefits legislation. The Canada Pension Plan is a self-funded contributory plan. Now, that's the reason I put the picture there. Because it's an open acknowledgement that it's self-funded by us and not the government. Okay? Now, going on to the next case, next one. Beatty, Ontario Superior Court, 1995. I'll read the whole thing off because it's important. The Attorney General's, this is their position, their legal position, okay? At the most general end of the spectrum of federal legislative regulation in this area, Section 67 of the Financial Administration Act, which makes Crown debts unassignable except pursuant to statute. Now that means it's only when they decide to allow an exception to the general immunity that there is an exception to the general immunity. A taxpayer has been held to be unable to assign his right to an income tax refund because of this provision. Marzetti versus Marzetti, Supreme Court of Canada, 1994, another case that I often refer to. This is the point I want to make, though. More specifically, both the Canada Pension Plan and the Old Age Security Act contain provisions, Section 65 and Section 36 respectively, generally prohibiting the assignment, charging, attaching, anticipating, or giving as security of benefits under the Act. Now, I've talked about that topic before. Why did the government use all these terms? Well, you'd have to ask the Department of Justice, right? The Department of Justice helped write these acts, and they put in there that these laws were going to prohibit the assignment, the charging, the attaching, anticipating, or giving as security of these payments. Now, I'll probably talk about it later in another video or do a post, but this all comes back from the King. Canada is a Westminster style democracy, and so we got a king as our titular head, symbolic head, and the king could do no wrong. The king couldn't be held liable. The king couldn't be sued. So there's a thing called residual crown immunity that has to be overcome by law, like the Crown Liability and Proceedings Act, set up in 1953. So I'm not sure if it was you couldn't sue the government before 1953, but after they set up the law that allowed a lawsuit, you certainly could. All right? So they put into a law, which is common sense, to allow a person to sue the Crown. Dealing specifically with pension entitlements, Section 1010 of the Public Service Superannuation Act was amended in 1992, and the relevant parts are as follows. Section 1010, subject to Part 2 of the Garnishment, Attachment, and Pension Benefit Diversion Act and the Pension Benefit Division Act, a benefit under this part, or Part 3, is not capable of being assigned. And then I got the picture cut off, but I can tell you it's assigned, charged, attached, anticipated, or giving as security. Now, see, the thing is, this is a thing that cuts both ways sometimes. Let's say you wanted to go get a mortgage, and you're disabled, and you're getting, say, the Pension Act pension. You can't go into a bank and give them that as security. You're not allowed to. If you did, it's void. Financial Administration Act, Section 67. Now, next picture I got here is from the 2007 Treasury Board Secretariat Total Compensation Report. Number 1, cost sharing, they call it. And the numbers are when I was footnoting at one time. So they said 70% of the sample employers covered full cost of this form of insurance, whereas the Treasury Board only pays 85% of the cost. We see that's a fib. They're gaslighting you there. That's what I'm trying to say about just because they make the payment doesn't mean it came out of their own money. Because the person who earned that in service, that's their money. See? I mean, it's logical. Now, to prove that point, in the comments, I put a picture from the Vote 20 thing, and it says that Vote 20, which is the federal public service insurance payments, that the government has to get a vote appropriation bill to get money to pay into certain programs. And they said that the Vote 20, the description of it said that these payments are made in respect of a person's public service. Now, you get paid for your public service. So the 85% that the government pays is just simply salary. There's nothing special about it. Now, the next one, I don't know as much that I could say about it, but the next picture I put up was about the Canadian Forces Superannuation Act and contributions. Now, I can't help it. I know so much about this stuff is unreal. This report was based in 2007. It covered the period between 1993 and 2003. But before the year 2000, federal pensions were only bookkeeper interest. There was no cash, no money put into federal retirement pensions. So when they're here talking about contributions from the employer and contributions from the employee, it's all fake. Because they didn't take money off of the person's check and they didn't deposit that money into a bank account for that person to be held in trust for their retirement. They didn't put money to match up against it to go into that account until 2000. Now, I'm surprised the government hasn't got sued for that, because that's breaking the law on pensions. You're not supposed to do that. Now, the next picture I put up was about the population of the Canadian Forces, and I was hoping when I put it up there that it went back into the 90s. But it only started in 2007 and 8. And it said that there are 63,716 regular force Canadian forces members. I think it's regular force. Now, what I was saying is that these people all paid into the SISIP plan. See? So the more money you have, the more people you have paying premiums, the more healthy your insurance plan is. Conversely, the more people that become disabled, the less people that are paying in, it's less healthy. Now, the next picture I put up there was the RCMP population from that same report, the 2007 Treasury Board Secretariat Total Compensation Report. And in 1990, there was 15,860 civilian RCMP members. Oh, the other way around. 15,860 uniformed RCMP members and 1,836 civilian members, for a total of 17,696. Now, if I recall, there was about 100,000 people in the Canadian Forces at that time. So when I look at the RCMP plan versus the Canadian Forces plan, there would have been 5 times as many contributors. There should have been probably 5 times as much risk of people becoming disabled and costing as much. But I'm trying to say it's all relative, in a way. Now, I just threw this one in there, to be honest. I'm not exactly sure why. But I did note something that bugged the crap out of me when they talk about government transfer income, which includes old age security and Canada pension plan, also increased post-release from $600 to $1,700. Well, they're not government transfer income. Remember, the Canada pension plan is fully funded by the contributor. So where do you get that that is a government transfer? I mean, this is the kind of shit that gets me on the go. Now, some people might say, who cares? Well, I don't like things that don't add up. Okay, the next picture I put comes from something I think was 2015 or 16. That was in the annex or appendix. And they admitted something that I never thought they'd admit in writing. They said the earnings loss benefit is an income tested. Now that's the term I didn't think they'd ever put in writing. Taxable monthly benefit which provides economic support, again, welfare, to veterans participating in Veterans Affairs Canada Rehabilitation Program. It also provides ongoing economic support totally and permanently incapacitated veterans. And you see, generally speaking, people get upset when governments use means testing or income testing for programs. When they brought in the first old age security system, it had means testing, and that drew a lot of flack. The current old age system has no income testing, not until 1987 when Brian Mulroney put it in there. And even then, they put it at such a high amount that it really doesn't matter almost. Now, now, these are not in any particular order. Next picture I got was from my own post. Rather than copying, I took the picture and copied it into Paint, and then I edited it. And from 7th of August 2015. Now this was about Veterans Affairs Canada plans and priorities. And they talked about the government will continue to recognize and support all veterans. So one of the expected results from Government of Canada's programs in this area of economic affairs is income security. Now that's a word I don't mind too much, remember? And employment for Canadians. This program aligns this as a result of providing regular monthly income. Now I don't agree with that. See, you're getting a monthly capital payment to a vulnerable portion of Canadian society. And they put an example, low-income veterans. Now, this is the clue that proves they know that this is welfare. Because they're only going to provide help to low-income veterans and not high-income veterans. So they say consistent with this mandate, Veterans Affairs Canada offers income support, that's the welfare term, to ensure program recipients receive monthly income to meet their basic needs, but not a copper more. When you're on welfare, they won't give you any surplus. That's the difference between the Pension Act, which didn't claw back things, and the new Veterans Charter, which is based on need. So therefore, they have to assess your need. So to assess someone's need, they use either a means test, which takes into account your property, or an income test, which is not as intrusive as a means test, but then they only look at income. Now, if you're only going to look at income, you ought to look at income for real, like pensions or property, not income. Now, next picture, I'm getting tired of this, so I think I'll clue it up. The Auditor General, the next piece of proof that I put into my post today as a, the proof that I'm not just spitting out bullshit that I come up with on my own. I'm not saying the earth is flat. I'm trying to say that these fuckers are gaslighting us. 2012 Fall Auditor General Report. The heading states, similar income support and vocational rehabilitation programs in each department continue to create confusion and difficulties. Well, let me tell you something, you sons of bitches. Veterans become veterans, either training for war or fighting in war for Canada. If you become disabled, training for a war or fighting a war for Canada, you're not supposed to get welfare. You're supposed to get compensated, just like a tort lawsuit. Because why should a civilian worker get the equivalent to a tort lawsuit in workers' compensation? But ever since 2006, the government does not have the equivalent for veterans. You don't get compensated anymore. Nobody gets compensated under this new system. The new system is based on needs. needs. Well, there's a couple there. I shouldn't have said that. But a couple that are not based on needs are things like the permanent impairment allowance, which used to be, became the career impact allowance, which then became the additional pain and suffering compensation, which is a whole other line of bullshit. They keep changing names for nothing. Okay, so let me see. I was talking about it, and I just skipped forward to the pictures before I go. Crown liabilities and proceedings Act Section 9, the heading, which is called the header in legal terms when you make a law, and it's not part of the act. It's only there to help you interpret the act. It's not, you can't quote that as government's intent or a law, but the intent of Crown Liabilities and Proceedings Act Section 9 says special provisions respecting liability. So that's the header. Section 9. Well, actually, I think I was mistaken. There's two things above the top of that Section 9, and one of them is part of the law. But the second one, what I'm about to say now, no proceedings lie where a pension is payable, that's not part of the law. But that first part I said, special provisions respecting liability, that is part of the law. Section 9. No proceedings lie against the Crown or a servant of the Crown in respect of a claim if a pension or compensation has been paid or is payable out of the Consolidated Revenue Fund or out of any funds administered by an agency of the Crown in respect of the death, injury, damage, or loss in respect to which the claim is made. Now, again, I'm not a lawyer, but allow me to impress or baffle the viewer when I could pick up on things that I can pick apart, even though, well, I'm not a layman. I've read so much, I think I can do a very good job of picking this apart. First of all, they don't tell us what proceedings is, but generally they're talking about legal proceedings. Okay, lie against the Crown. Well, what about different departments? You have the Department of National Defense and the Department of Veterans Affairs often try to pit each other against something, but here they just lump together the Crown, and then they say, or a servant of the Crown. Well, I think they're talking about personal liability of the person, which should be a moot point. When you think about vicarious liability, it's called. If you get hurt in a store, say Canadian Tire or some other company, the person who hurts you works for the company. You don't sue the worker, you sue the company. And the reason is it's called vicarious liability. Okay? The employer has insurance against liability. The worker doesn't. So here I think they're talking about you can't sue the person individually in respect of a claim. Now, in respect of is a legal term of art that's talking about the connection between two things. Okay? So if you serve the military, you get paid in relation to that service. If you get injured in the military and you get paid compensation, according to the Supreme Court of Canada's Sarvanis case, it's paid in the event, related to the event that caused the injury, not the disability itself. Now, the next thing they say, in respect of a claim, if a pension or compensation has been paid. Now, it's my ongoing theory that the government doesn't understand the word compensation, that they think this means income. But in terms of damages, compensation has a special meaning, and that means that you're getting an amount of money that's supposed to balance the scales about the injury you suffered. See? Now, has been paid or is payable. Now, that's a problem because it's ambiguous, it's vague, okay? Because an amount of money that's paid is certain. But when they say or is payable, that's much more uncertain, isn't it? You could have a claim, an application in for a pension like pension. And that's where they say it will be payable, but you haven't been approved. They might not approve you. So why should you be barred from a lawsuit? Because they're going to say that it's payable. Now, maybe it's in between that, like after you get approved, but before you actually get the money. Maybe they could mean that. is payable out of the Consolidated Revenue Fund. Now, to me, this is a red herring, because they're talking about money that's coming out of the taxpayer's purse, right? All government general revenue goes into the Consolidated Revenue Fund. But there are certain funds that are not part of the Consolidated Revenue Fund, such as SISIP. It's part of the non-public property funds. The Canada Pension Plan, the Canadian Forces Pension. These are all supposed to be segregated, not part of the Consolidated Revenue Funds. I don't understand, as I'm reading this, how did the government, the Department of Justice, try to pull a wool over the court's eyes in the Sarbanes case? Because they tried to say that the Canada Pension Plan disability was one of these payments that was barred by Crown Liabilities and Proceedings Act, Section 9, and that's just bullshit. The next part is out of any funds administered by an agency of the Crown, and then again, the in respect of the death, injury, damage, or loss in respect of which the claim is made. Now, another criticism I would have of this, and again, I'm not a lawyer, but I think I'm a legal scholar. I do a lot of reading about law. There's an awful lot of words in this section of the Act with no sentence division. So it's one big run-on sentence. Now, I don't know if they think that that's good grammar, good English, but I think it makes for a lot of confusion, right? Because they say death, injury, damage, or loss. Now, that's 4 different things, right? And then, is it all of those put together, or is it in respect of which the claim is made? Well, where is the claim being made? Is the administrative claim, the workers' compensation, or Veterans Affairs? Or is it, a claim against someone in a civilian context, or in a tort lawsuit? Anyway, I'll get away from that. Now, actually, I almost forgot about the other idea, because the next picture that came up, and this was something that popped into my head this evening. Well, I thought of similar things before. It's not exactly an inflation calculation, but I went into the Bank of Canada's inflation calculator. I punched in $100 because that was what was there, and that's good enough for me. Then I put in 1 year, 2016, 1 year, 2017, and said calculate. Lo and behold, it spits out that there was 1.56% inflation in between those 2 years. So therefore, I don't exactly have a problem with the cost of living allowance on the service income support insurance plan being limited at 2%, because the inflation was below the 2%. Right? Now, in next year, though, the inflation was 2.31%, which is 0.31% higher than the limited cost of living allowance on the SISIP long-term disability. Now, where I'm coming from with this is that the Service Income Support Insurance Plan forms 83.3% of the income replacement benefit, because the program arrangement between Veterans Affairs Canada and SISIP says in section 3.2.1 that the SISIP Financial Services will be the first provider of income replacement in the event of a medical release. Now, SISIP has a cap of 2%. Veterans Affairs Canada doesn't have a cap anymore. They did have a cap between 2006 and 2016. That's why I chose these years. So after the cap was lifted at Veterans Affairs, inflation was slightly higher in 2018 than it was in 2017. Now, under the SISIP program, which again forms 83.3% of the income replacement benefit, that means that the person is only going to get 2%, because the 0.31 is in excess, higher than the capped limit. Now, Veterans Affairs Canada then has to pay the remaining portion ever since October 2016, when they increased the income replacement benefit to 90%. So does that mean Veterans Affairs Canada only pays the difference, like the 0.31% difference on the income replacement benefit, or as I think they should pay 2.31% on all of the income replacement benefit, because the government, and I got a picture of it here, and I got to open in my screen here besides. Back in September 2016, the government announced that it wasn't fair to have a cap of 2% on the income replacement benefit. They said, according to the budget introduced in March 2016, included additional financial support for veterans, including indicating that the new Veterans Charter needed to be enhanced to meet the needs of modern-day veterans. So they were going to, third point, expanding access to higher grade, I forget that one, okay. Increasing the earnings loss benefit to provide income replacement of 90% before deductions, removing the 2% cap on indexation to allow it to keep pace with inflation. Now you see, this is what you call an admission of guilt. The government shouldn't have had a cap on the cost of living, and it took them 10 years to admit it. So between 2006 and 2016, the government had a cap of 2% on SISIP, a cap of 2% on the earnings loss benefit. Starting in 2016, the government, in its infinite wisdom, decided to get rid of the cap on the income replacement benefit. But remember, SISIP forms 83.3% of the income replacement benefit, and they're still capped at 2%. So Veterans Affairs Canada is getting a huge benefit by retaining the 2% cap, but making it look like somebody else did it. I think that's pretty important. Now, the final point I'll make on this, I could talk about this for a long time, but I'm getting tired. My throat's getting dry. A thing called public policy, okay? I'm always talking about public policy. Public policy is supposed to be good public policy, not bad public policy. Now, having a cap of 2% on the cost of living is bad public policy. How do I know that? Well, in 1973, they took the 2% cap that they had on the old age security and the Canadian Forces and the public service and the RCMP pensions. They all used to have a cap of 2%, but they took it off in 1973. 1974, they took the cap off of the Canada Pension Plan. So, we know it's good public policy to allow people on a fixed income to keep their money even with inflation. So, the thing is, how did they get away with having all of the federal long-term disabilities kept at 2 or 3%? How did they get away with the fact that the RCMP and the public servants get 3%, which is one whole percentage more, which is 1/2, which is 50% higher than a disabled Canadian Forces member gets? How are they getting away with 2006 to 2016? Because they copied SISIP, they copied the 2% cap into law. So instead of it being a provision in the contract, they had a provision in law. But somebody at that time should have said, this is not good public policy. Public policy is one of the things that you can argue in a contract. When something's bad in a contract, you can say it doesn't apply even if it's in a contract because it's bad public policy, so it cannot be supported. So these people seem to think, and this is one of my overriding themes, they don't care if it harms you as long as it's legal. But need I remind the viewer about how I'm always talking about equity law? Equity law is about justice, not legalities. So you might say, it's in the contract, it's there, too bad, suffer. Well, I didn't put it in the contract. You never negotiated with me. I didn't put my signature on it. I didn't agree to it, and it's bad public policy besides, you son of a bitch. Anyway, on that note, I'm surprised I got as far as I did, because I thought at the beginning I was going so fast that I would be finished in a flash. Thanks for watching, if you're watching, of course, and I'll see you next week.